The Supreme Court of Nigeria last week ordered the retrial of a former governor of Abia State, Orji Uzor Kalu, who a few months ago was sentenced to 12 years in prison by a federal high court in Lagos for embezzling 7.6 billion naira belonging to Abia State. The reasons adduced by the Apex Court for its decision has been given diverse interpretations within judicial circles and continues to cause even greater debate among political analysts, some of whom are convinced that this ruling has not been reflective of the gross misappropriation of public funds in the state, which took place under the former governor between 1999 and 2007. Others say that by this, the Supreme Court has taken yet another step towards alienating itself from the people. On the other hand, a short way across the boundary into Rivers State, Governor Nyesom Wike's interpretation of the COVID-19 lockdown directive is being described as anything but what those safety guidelines stipulate in terms of formulation and execution. The governor, acting on what he calls a substantive executive order, has been arresting alleged offenders of the lockdown order, locking them up, demolishing buildings, and even arresting professionals who are by the extant laws considered to be providers of essential services. What are the likely immediate and remote effects of all of this on Nigeria's current body of laws? We shall be seeking answers to all of this from renowned lawyer and senior advocate of Nigeria, Chief Mike Ozekhome. Chief Ozekhome, good morning.
Good morning.
Yeah. Good morning, all.
Morning, Chief. Good morning. Good to have you again on the morning show. Yes.
You always remember my title.
But anyway, this morning we're going to discuss legal matters. But before we talk about the matter of the Orji Kalu case, let's first of all talk about Rivers State, where on Sunday the governor led a team to demolish two hotels, one in Eleme, the other one in One, on the grounds that the owners of those hotels had violated an executive order that he had issued. Now, Governor Wike has come under virulent attack from all sides. He's been accused of high-handedness, of trying to be the judge, the jury, and the executioner in his own matter, but he insists that it's a matter of law and that he has done no wrong. And, you know, others have said he's a member of the body of benchers. He should know how the law operates. But what's your take on that situation in Rivers State, where the governor is now arresting people, demolishing buildings, and insisting on the law?
Well, my take is very simple. Where the governor finds people violating the law or the lockdown, he should hand them over to the security agencies, that is the police. The police has a right to deal with anybody and also to prosecute people who violate the law. Surely the governor cannot by himself prosecute people, but surely he has the power to hand over people who are violating the law to law enforcement agencies. Even any Nigerian, any ordinary Nigerian, if you see a person committing a crime, apart from the police under Section 4 of the Police Act, and apart from the DSSS or the security agencies, any Nigerian who sees any other person committing a crime is also empowered by law to arrest such a person and hand him over to the police. And then the police takes it from there. Anything beyond that would be illegal and unconstitutional.
Certainly, that is the take that most people have. But what options would you say are available now to those that have been affected in Rivers State, especially by the demolishing of so many buildings? What would you advise that they do? And what is your legal take as well on the current rift that's going on in Rivers between the governor and the DPO of police that's also causing a lot of problems? Your legal take on that?
I'm always a rule of law person. I believe that everything we do in this country, in spite of all the difficulties we are having, should be done according to rule of law, according to due process. Anyone whose rights have been violated should also immediately seek legal remedies against whosoever violates such rights. In a court of law, we cannot be a client or a country of resorting to self-help. We don't resort to self-help. We don't use arms and ammunition. We use the law. The law, at the end of the day, remains the mantra. It remains what you call rule of law, which was ably propounded by Professor A.V. Dicey, that we are all equal before the law, and that whatever happens, we should always resort to the law. Otherwise, we'll be back to the Hobbesian state of nature, where life was short, nasty,
and brutal, brutish,
and foolish.
Well, Chief Ozekhome, now let's talk about the ruling last week by the Supreme Court. A 7-man panel of the Supreme Court upturned the ruling of Justice Mohammed Idris in the matter of Orji, Kalu and another, at the end of which Orji Kalu, former governor of Abia State, was sentenced to 12 years. Now, the point of their lordships is that, one, the judge lacked jurisdiction because he was already functions official by the time he sat over that matter, having been promoted since 2018 to the Court of Appeal, and that a Court of Appeal judge cannot sit over a matter at the High Court. Second, they also ruled that Section 296, Subsection 7 of the Administration of Justice Act, ACJA, is inconsistent with Section 253 of the 1999 Constitution, and is to the extent of that inconsistency void in the particular matter at hand. What is your own view on this? Because I'd read an essay that you wrote, but for the benefit of our viewers, do you think that the Supreme Court was right, or the Supreme Court could have taken another approach?
I believe that the Supreme Court was right. And that write-up you are talking about, actually, I wrote it as far back as December 5. It was the serialization in these day lawyer pages, December 5 to December 25, 2018. Like Nostradamus, the man who saw tomorrow, I was peering into the future, looking at what exactly the law says. And the Supreme Court was right. I'm surprised when I hear many people, even some senior lawyers, who are actually in a position to advise members of the public who do not know the law, because we are not all lawyers. For example, I'm not a medical doctor, so I'm not a specialist or a scientist in COVID-19. I will not pretend to be one. When I see senior lawyers who ought to know and ought to actually educate the public not doing so, it nerves me. We should tell the public that jurisdiction is a threshold matter in legal adjudication. It is not a matter of sentiments or emotion. Jurisdiction is so important that the Supreme Court has defined it as the spinal cord of any adjudication. And that no matter how well proceedings have taken place, if eventually it is found that there was never jurisdiction in that case, such proceedings will be set aside, no matter how beautifully concluded. That is why jurisdiction can be raised at any time, whether at the first court, whether at the second intermediate court of the Court of Appeal, or even for the first time at the Supreme Court. So the issue of Section 396, subsection 7, conflicting with various sections of the Constitution, like Section 150, which gives the Attorney General powers to give fiat, like Sections 249 to 253 of the Constitution. All of them are matters that are jurisdictional. They are not just cosmetic. They are not just plastic. They are not just technical, as some people have been bandying about that, oh, the Supreme Court went technical. It should have gone purposive in its interpretation of the law. Where the law is clear, how can you begin talk about leaving literal interpretation of law to what you call purposive interpretation of law to begin to look like a knight errant or like a Mongo Park who was said to have discovered the river Niger, even though he met the natives drinking the water and taking their bath there. How do you begin to go about looking for the purpose of what you thought the legislature meant when the very law itself is clear? The very law is that a judge is either a judge of one court or the other. You cannot be a judge of two courts. You cannot wear two caps. If you are a Kabiyesi or an Emir or an Obi or Eze, you can only be a Kabiyesi, Eze, or Emir in one palace, not in two palaces. You cannot be a justice of the Court of Appeal and at the same time come down to the Federal High Court to still continue a matter that you have been hearing before you were elevated to the Court of Appeal. Before I go into the facts briefly, Ruben and my sister, the bat is an animal and it's also a bird. That's what it says. If we go to the animal kingdom and say, hello, I am one of you, they will ask him, how can you say you are an animal when you are a bird and you fly? He will say, look at my teeth. If you check the bat, it has teeth like a human being. If you check the ears, the pinna, the ears are just like that of a human being. Guess what? The most surprising, God is wonderful and awesome. The bat has mammary glands, breast, like a human being. The animals will therefore accommodate the bat. I say, okay, you have been able to prove that you are one of us. Then the bat will leave the animal kingdom and go to the birds kingdom. I say, I'm one of you. The birds say, no, you can't be one of us. You are an animal. You are just coming from there. The bird say, you want to try me? Let us fly together. Birds fly. And I can beat you to flight. And the birds will fly with the birds. So only
Chief
a
Ozekhome.
Just 2 words.
Chief Ozekhome, your opinion and your analysis and analogies are very much appreciated here. Let me get your opinion on something. How do you respond to critics of the judgments that are saying that he was not the applicant and it was actually his co-defendant, Ude Jones Udeogu, and therefore this ruling doesn't apply to him? What's your take on that?
Let me tell you that the Supreme Court has heard in several cases that where there's a joint trial with similar evidence, the same witnesses, the same exhibits, then all the parties must enjoy the fruits of that trial. You cannot pick and choose. In the trial between Jones Udeogu, Orji, Uzor, Kalu, and Slop Nigeria Limited, 11 out of the 29 counts were exactly on conspiracy between Orji, Uzor, Kalu, and Udeogu. 11 of them were exactly on the same, they were all convicted on the same count. And Orji, Uzor, Kalu was sentenced December 5 last year with Jones Udeogu, Orji, Uzor, Kalu for 12 years and Udeogu for 10 years. So they were swimming or sinking together. That was why none of them could be exculpated. So whatever applies to Udeogu also applies to Orji, Uzor, Kalu, although it was Udeogu who actually appealed to the Supreme Court. You cannot separate the two. Let me quickly make this point clear that some people are making a mistake. The judge who had the matter at the Federal High Court had already been elevated on the 20th of June, 2018, to the Court of Appeal. And on the 22nd of June, 2018, he was duly sworn in as a justice of the Court of Appeal. That means he now became a justice, not a judge. The law is that if you look at the provisions of the Constitution, which is supreme to Section 3, 296 subsection 7 of the Administration of Criminal Justice Act, ACJA, under section 1, subsection 3. If you look at sections 239, if you look at sections 249, sections 251, 252, 253, 254 of the Constitution, you will see that the Court of Appeal has its own functions. At three, justices must sit. The Federal High Court has its own function. At least one judge, not justice, must sit. So a Federal High Court or a High Court is a court of first instance that hears trial of matters, take evidence orally. A Court of Appeal will never take evidence orally. It hears appeals from that Federal High Court or from the High Court. So a judge who has been elevated, as the Supreme Court itself has heard, in Ogbunya versus Okudo, and also in our line versus NSS, and also in Shoden in these cases, even before now, that once Justice Nnameka Agu was elevated to the Court of Appeal, Federal Court of Appeal then, and once Justice Igu was elevated to the Supreme Court from the position as Chief Judge of Anambra State High Court that time, then they both ceased to be judges of the High Court, and they have become either justice of the Court of Appeal or justice of the Supreme Court. That to that extent, they had no jurisdiction to still continue and hear the matter that they were hearing. To do so is grave injustice.
Well, Chief Ozekhome, the point about jurisdiction is very clear, but I would like to take you up on a comment that you made earlier when you complained about some senior lawyers and some of the phrases you quoted about purposive approach. I guess you were quoting from Kenneth Ikone SAN, who wrote a piece in which he alleged that he disagrees with the Supreme Court justices because they seem to have been guilty of it. By Kenneth Ikone SAN, yes. He accused their lordships of slavish devotion to technicality. And he went on to say that a purposive and liberal approach will have led them to a different conclusion. And in his view, the ACJA, section 396, subsection 7, was put there in that ACJA in order to cure a particular mischief that we had in the past, whereby, you know, the examples that you cited, if the judges had gone to the Court of Appeal, and then, of course, and they came back to conclude the case, then the case would be dismissed, and then it will start de novo. And that their lordships should have paid attention to that mischief, and that would have been a more purposive and liberal interpretation. Otherwise, what you will have, now that the Orji Kalu case has been thrown out and has been asked to go back for retrial, originally that case took 12 years. So are we now going to have another 12 years? You may say not necessarily. How about witnesses who may be relevant, who may have died? How about evidence that may have been tampered with? And then at the end of the day, will justice be done?
Let me quickly correct certain things. It is an error. That case, the retrial of that case started on the 31st of October, 2018. They were rearranged after a new plea based on fresh amendment just in July last year, 2019. So this question of saying the case took 12 years, all those are also not correct. It is true that when the first arraignment was done that time, Orji Uzor Kalu fought certain aspects of the case up to the Supreme Court, which was why when he lost at the Supreme Court, he was now arraigned finally on the 31st of October, 2018. Let us get this one clear. And then on the 27th of July, just last year, July, he was rearranged and he took a fresh plea based on amendment. So we should not always confuse some of these things. It is not true. It was a trial that has been going on for 12 years. The trial started 31st October 2018 and ended on the 5th of December 2019. About a year and 6 months later when it started. Let me tell you why I will disagree with that lawyer. I didn't read that article. It's just that I know that, you know, the social media has many true-ups. Oh, they should have been proposing. And one lawyer who believed in judicial activism. Judicial activism to the extent that, like Lord Denning, Master of the Rose, the philosopher king of law, once said, he said, yes, judges, you can seek to iron out the creases of a material with which law was made, but you cannot remake the law. I give you an example. The same prosecution people, I have been with a case with them for about 2 to 3 years in one of the northern parts of Nigeria. I wanted the case had immediately because the judge was retiring in December last year. We went on and on because I didn't want to be going back again all the way by road to go and be hearing that matter. And because the client, the defendant, was litigation weary. But guess what? On the 31st of December 2019, the judge, by constitutional exclusion of time, retired from the bench. It is like saying, oh, because I desire that this matter must be heard, oh, that judge who has retired by constitutional exclusion of time should be brought back to come and hear this matter. Do you know what? The whole trial has just started de novo, and it's coming up in the next few weeks. That is the law. Jurisdiction is a threshold matter. It is a very serious matter. It is not a matter where you begin to talk about purposive interpretation. The Supreme Court cannot remake the law. The Supreme Court cannot amend the law. That is within the province of the legislature, the National Assembly. What the National Assembly should do, thank God the Constitution is undergoing constitutional amendment right now, is to engraft Section 396, subsection 7, into the body of the Constitution under Section 9.
Chief Ozekhome.
Not as an act of parliament, which is inferior. The Administration of Criminal Justice Act is an inferior law. It must blow muted trumpet when faced with the caveat of the law, and that is the Constitution, the grand norm.
Well, Chief Ozekhome, quickly, I'll need you to help us clarify something. I get your argument, but what if the case now starts de novo, and then it's assigned to a judge of the Federal High Court, and then somewhere down the line, that particular High Court judge gets promoted again to the Court of Appeal? What happens? The case will start afresh?
Oh, too bad.
And then the case will never end.
No. Well, if the prosecution or the chief judge of the Federal High Court, in assigning a case to a judge, we only assign it to a judge who is likely to be promoted in the next 1 year, too bad for the system. You cannot change the system because of exigencies. I believe that do you know how many Federal High Court judges we have in Nigeria? Oh, there are tens and tens and tens and tens. Some of them are very junior, appointed only 2 or 3 years ago. So why should it just be that it will only be a judge that has the potential of just being a justice of the Court of Appeal? But if they give it to a judge of the Federal High Court who have the potential of being a justice of the Court of Appeal and is again promoted, oh, so well be it. Then they start afresh. I think we should be careful not to destroy democracy on the whims and caprices of political exigency. They don't go together. We either have pure and undiluted democracy, or we decide to say that we are practicing fascism or dictatorship. Democracy, one of the adjuncts of democracy, is rule of law, that things must be done properly, that constitutionalism, which governs our client, the watchword. So you cannot say, for example, that because a judge was so good to a case, you now want him back after he has retired. You will start afraid. This is not the first time. The same prosecution itself has many cases. Let me now tell you where they did right against certain judges hearing certain matters. After, for example, 12 witnesses had been taken
about 11 to 12 witnesses have been taken out of 14. I think that is the case of Fayose, Federal Republic of Nigeria versus Fayose. But because of that petition, the judge was told to recuse herself. The judge, I think, has now retired. And the case has to start de novo. It started all de novo. The prosecution, the Federal Republic of Nigeria cannot always blow hot and cold simultaneously. In Josiah versus...
Chief Ozekhome, please, sorry to interrupt you. We need to take a short commercial break. We need to take a short commercial break. Please stay with us. When we return, the conversation will continue. We'll take a short break now. It's still the morning show. Welcome back to the morning show here on Arise News. Still with us is Chief Mike Ozekhome, Senior Advocate of Nigeria, who has been helping us to address a number of legal matters in Nigeria. Leila, over to you.
Yes, Chief Ozekhome, I was going to ask you if you could help us to shed more light on something. Of course, we know that Orji Uzor is still being held by the authorities, and I'm sure our viewers would like to understand more about the process that it takes with regards to his release. Can you talk us through this?
Well, I just got to hear that through the social media just last night that he has not been released. Of course, like I said earlier, what affects one, that is Ude Jones Udego, affects Orji Kalu because they were tried together with 11 count charge. Then each of them now had their separate ones, and they were convicted together, sentenced together on the same 5th of December last year, meaning that they share the same umbilical cord. They are the same 6.5 dozen. Now, it therefore means that since the Supreme Court judgment, and Nigerians should also know this, many Nigerians who are saying, oh, maybe the fight against corruption is being lost or that. Let Nigerians be advised that the Supreme Court did not discharge or acquit Jones Udego, which judgment Orji Uzor must also enjoy. The Supreme Court merely said because the justice of the Court of Appeal, who had been appointed, lacked jurisdiction to descend again and come down to a lower court to still wear the wig of a federal high court judge and hear the matter should go back to the chief judge to reassign to another judge for trial de novo. That means to start the trial afresh. So it is not that Udego himself was even discharged or acquitted by the Supreme Court. Just the same way the Supreme Court has not discharged or acquitted by Orji Uzor. They will still again be rearranged before the court and retried. So it means that if any of them, if both of them or any of them is still being held by the National Correctional Service, which is a better word anyway, I must commend this administration for that amendment to the Act by calling it National Correctional Service instead of Nigerian Prison Service, because the word prison itself is not reformatory, it's not correctional. I praise this government for that. Well, if they have not released Orji Uzor and Udego or any of them, because they are saying the judgment only pertains to Udego, who had appealed by instead to the Court of Appeal, I think they are wrong. They should be advised to release any of them who are still being held in detention. And otherwise, what happens? I always believe in rule of law. Nobody can carry a gun or an axe or a bayonet to go and fight. Rather, whoever is free in detention should contact his lawyers. They should know what to do by going to a court of law to seek enforcement of the judgment of the Supreme Court.
Well, Chief Ozekhome,
not back to the Supreme Court, but a lower court.
Yeah.
At the High Court.
Chief Ozekhome, I would like you to help us clarify two things. One, what are the implications of this ruling by their lordships for other cases that may fall within the same category? The Administration of Criminal Justice Act having been in effect since about 2015. I imagine that there will be other cases that will have been determined on the basis of the application of Section 396 of Section 7, as it were. And then second, there is the allegation, I know morality is not law, but some persons have raised the question that originally it was counsel to Chief Orji Uzor Kalu, in this case, Godi Uche SAN, who actually wrote to the President of the Court of Appeal to request that Justice M.B. Idris should be the one to handle and conclude the case at the end of the day. Now, is there a question of morality here? Now, the thing has turned 360 degrees, and the party is benefiting from what it originally was the author of it, more or less.
Let me start with the first one. Like Pontius Pilate, who washed his hands of the trial and crucifixion of Jesus Christ, now that the prosecution and all other courts and justices already promoted or elevated to the Court of Appeal, who are still hearing matters, have now had the Supreme Court, the apex court, the last court of law in the land, loud and clear that Section 396, subsection 7 of the ACJA is unconstitutional. They should quickly wash their hands of those cases and bundle the case file back to the chief judge to reassign. Otherwise, it will be a journey again to no destination, a flight without a compass. There's no question about that. We cannot, there's nothing anybody can do about it. That is the law. They should quickly, let me tell you also, I'm also aware of some judges who were also handling other matters. When they were elevated to the Court of Appeal, and they told them they were going to give their chair, such justices refused immediately and said, no, I cannot wear 2 wigs. I cannot be a justice of the Court of Appeal and be a judge of the High Court or Federal High Court. I do not want to mention their names, but they are there. So it's a question of discretion. On the second point, that Godi Uche, SAN, was the one who actually wrote that letter. I think that letter was written on the 7th of July, 2018, telling the President Court of Appeal, give a chair to the prosecution to still continue to do this. He may have committed a genuine error. Whether it was genuine or not, I wouldn't know. But the important thing is that the law is clear, and the Supreme Court again, in ringing tones, has held again and again, time without number, that parties or their counsel cannot voluntarily, whimsically, capriciously, arbitrarily confer jurisdiction on a court of law that has no jurisdiction, because jurisdiction is donated by either the Constitution or a statute. No party, no matter how you like the court, I cannot say, for example, I like my cases to be at the Supreme Court. Because of that, I go to the Supreme Court to go and file a case where the Supreme Court has no original jurisdiction, which is between states and states, or between the federal government and states. Then I say, because I like the Supreme Court, then we write to the Supreme Court. And the Supreme Court say, okay, bring the case, we will hear it. Or you write to the Federal High Court and say, we want you to hear a matter concerning libel, defamation, which is not within the jurisdiction of the Federal High Court under Section 249 to 254 of the Constitution, especially Section 251. We want you to hear this case of defamation. Then you just say, okay, I hear this case of defamation, and he hears it. That will not, the fact that I or me and the other counsel and the other parties have agreed that the Federal High Court should hear this defamation case, that does not donate jurisdiction to the Federal High Court. It is either constitutional or statutory. So that argument, therefore, goes to no issue at all. It doesn't. In fact, if I were a prosecution and such a carrot is that goes before me, I would see it as a poisoned chalice. I would reject it immediately. I would say no. Having been elevated on the 20th of June, 2018, and sworn in under the 7th schedule, and under Section 296 3 of the Constitution, the equivalent of 254 of the 1979 Constitution, under which Ogbunya's case was decided, I would quickly say no, I will not allow a fiat to be issued by the President of the Court of Appeal, who has no jurisdiction under Section 1 and Section 19 of the Federal High Court. The Chief Judge of the Federal High Court under Section 1 and Section 19 of the Federal High Court is the only one that has jurisdiction to assign or give a fiat or reassign a case that is pending before the Federal High Court. The Supreme Court also found out in its judgment that this was an usurpation by the Court of Appeal President then of the power of the Chief Judge of the Federal High Court. These are serious issues of matter.
Chief Ozekhome, let me come in here. Let me come in here and ask you something. Now, critics have also asked a question, and I'd like to ask you whether you think it's a valid or invalid question. Critics are asking why this trial was given a speedy hearing when there is, of course, constraints with regards to the pandemic. Would you mark this as valid or invalid?
I didn't get that. Sorry.
Okay, so critics are asking why his case was given a speedy hearing when we have constraints, of course, being caused by the coronavirus pandemic right now. Would you say that this is a valid question, or would you mark that as invalid?
Maybe unknown to such critics, they didn't read the practice directions of various courts. The Court of Appeal has been sitting. For example, I've been to the Court of Appeal 2 times since the coronavirus pandemic started. I was at the Supreme Court just before it started. And I've been at the Federal High Court 2 times since the pandemic started, because the same court sent hearing notices for matters that are urgent matters, not everyday matter. So a case cannot be decided if the Chief Registrar of the Supreme Court did not send hearing notices to the parties, because the Supreme Court is there sitting. So unknown to many people, many courts in Nigeria have actually been sitting to dispense with time-lined or time-bound matters. There are many election petition matters and cases that, under the Constitution, if you do not decide that within a particular time, they will expire by a fraction of time. And the Supreme Court has said in many cases that time given under the Constitution to dispose of a matter is like the rock of Gibraltar that cannot be moved. It is also like it's also like Mount Zion. They cannot be moved. The Supreme Court has said that. So for such matters that are very urgent, that require urgent hearing, the Supreme Court, the Court of Appeal, the High Court, and the Federal High Court across Nigeria.
Okay, Chief Ozekhome, quickly before we go, it's good you referred to the courts. And I'm aware that the National Judicial Council has rolled out a policy on the adoption of technology. And in many states, in Lagos, in Borno State, we've had situations where, there is a remote sitting of courts, the use of Zoom technology, the use of virtual technology to determine certain cases. Now, is this something that you think is a good development, or is it an unconstitutional move, considering that it may seem to contradict Section 36 of the 1999 Constitution?
That's a very good question. And let me again sound a note of warning very quickly too. Many cases that are hard using the Zoom system or the virtual imaging system are going to run into troubled waters later. I know technology is good. Oh, yes, it was Hippocrates who said desperate diseases require desperate remedies. And it was Albert Einstein, the physicist, who said it's only a mad person who desires different results by continuing to do things the same way. So it was therefore necessary that technology be developed. This is the time for the National Assembly to quickly move in and amend certain sections of the Constitution. Section 36 of the Constitution is clear. And when you are hearing a case, particularly criminal cases, the people must be physically present to have their rights determined. And
using a lawyer of their choice. And this decision, this judgment, the hearing, the proceedings must be done in open court, in the presence of everybody.
Quite correct. And thank you very much, Chief Ozekhome. On that note, we have to bring this conversation to a close.